Every organization today operates within a dense web of obligations, legal, regulatory, and contractual, that shape how it must manage information. These layers often overlap or even conflict, creating a complex compliance landscape where one misstep can result in financial penalties, legal action, or lasting reputational harm. Control A.5.31 requires organizations to identify, document, and continually monitor these obligations so that every component of the information security management system aligns with external expectations. Compliance cannot be treated as an afterthought. It must be woven into policy design, risk management, operations, and auditing. ISO's approach transforms compliance from a reactive task into a structured governance discipline, ensuring that the organization's security program is both defensible and adaptable in an ever-changing legal environment. Building a register of obligations is one of the most tangible ways to operationalize A.5.31. The register should include all applicable laws governing data protection, cybersecurity, employment, and workplace safety. Industry-specific regulations, such as those in finance, healthcare, or energy, must be clearly documented along with their control implications. Contractual clauses with customers, partners, and suppliers often contain security, privacy, and audit requirements that must be tracked and verified. Voluntary frameworks, such as codes of conduct or ethical commitments, add another layer of accountability when an organization publicly pledges adherence. Each entry in the register should identify an owner, last review date, and evidence reference, creating transparency for auditors and leadership alike. Legal and compliance teams are central to interpreting these complex obligations and translating them into actionable ISMS requirements. Their role is to bridge legal language and operational execution. They guide decisions on risk acceptance versus mitigation when laws impose difficult or ambiguous requirements. Compliance specialists coordinate closely with ISMS owners to ensure that policies, controls, and training reflect the current state of law. They also act as organizational representatives during audits, investigations, and disputes, providing context and demonstrating due diligence. This collaboration ensures that legal oversight is not isolated in a corporate silo, but integrated into the daily rhythm of information security management. The legal environment exerts direct influence on how an ISMS is designed and operated. Breach notification deadlines in data protection regulations, for instance, shape incident response timeframes. Encryption requirements imposed by financial regulators dictate technical control configurations. Retention periods mandated by record-keeping laws determine how long logs, backups, and customer data must be stored. Cross-border data transfer rules force organizations to examine their hosting arrangements and contractual safeguards. Each of these obligations must be reflected in risk assessments, procedures, and controls. By anchoring ISMS operations to these concrete legal mandates, organizations convert compliance from a theoretical objective into an operational reality. These obligations are inherently dynamic, constantly shifting as legislation evolves and market conditions change. New privacy and cybersecurity laws emerge almost yearly, often carrying extraterritorial reach that impacts multinational organizations. Regulators may issue updated guidance following high-profile breaches or court rulings, changing the interpretation of existing laws. Contractual requirements evolve as customers demand stronger assurance clauses or as suppliers enhance their own compliance expectations. Global operations multiply this complexity, requiring organizations to reconcile overlapping or conflicting laws across borders. The only effective response is continuous monitoring, treating regulatory intelligence as a standing business function rather than a periodic audit task. Proving compliance requires evidence integrated into everyday practice. A current and well-maintained obligation register is the cornerstone of that proof. Policies and procedures must explicitly reference the legal frameworks they address, showing alignment between external mandates and internal controls. Monitoring logs, training records, and operational metrics serve as ongoing indicators of adherence. Periodic compliance audits, both internal and external, validate that controls remain effective and up to date. When audit findings or regulatory changes occur, the results feed directly into the ISMS improvement cycle, demonstrating that compliance is an active, self-correcting process rather than a static certification target. The consequences of failing to meet these obligations extend beyond fines or formal penalties. Non-compliance can trigger litigation, breach of contract, or even personal liability for executives and board members. Financial sanctions may erode profitability, but the deeper damage often lies in the loss of trust from customers, partners, and regulators. Contract terminations or revoked licenses can halt business operations entirely. Reputational harm lingers long after legal disputes are settled, undermining customer confidence and investor value. A.5.31 is therefore not merely a legal safeguard, it is a cornerstone of corporate credibility, translating abstract laws into practical, preventive governance. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Control A.5.32 turns the organization's attention to the often overlooked domain of intellectual property rights, or IPR, while A.5.31 governs external obligations imposed by law and contract. A.5.32 focuses on protecting the organization's creative and innovative assets, its software, designs, research, and brands, while ensuring that the rights of others are equally respected. In a knowledge-driven economy, intellectual property is both a strategic advantage and a target for theft or misuse. The control requires that IPR protection be built directly into the ISMS framework, ensuring that security, confidentiality, and legal compliance reinforce one another. It emphasizes clear ownership, proper marking, and disciplined access to proprietary information. By embedding IPR management into daily workflows, organizations demonstrate stewardship of both their own ideas and the intellectual contributions of their partners, employees, and suppliers. The scope of A.5.32 extends to every form of intellectual property that the organization creates, uses, or stores. This includes software source code, algorithms, design schematics, research data, trademarks, brand assets, and proprietary business plans. It also encompasses trade secrets, unregistered knowledge that derives value from being kept confidential. Each of these assets must be identified, classified, and governed by controls appropriate to its sensitivity and value. A lost prototype, leaked formula, or stolen algorithm can cause as much harm as a data breach. Protecting intellectual property is thus inseparable from information security. Both aim to safeguard the lifeblood of the enterprise, its ability to innovate and compete. Internal controls for intellectual property protection begin with proper labeling and segregation. Proprietary materials should be clearly marked to denote ownership and classification, reducing the risk of accidental sharing or misuse. Controlled repositories, such as version-controlled code systems, research databases, or secure design vaults, restrict access to authorized personnel only. Non-disclosure agreements, NDAs, must be executed with employees, contractors, suppliers, and any external partners before sharing sensitive content. Monitoring systems should detect unauthorized downloads, transfers, or external disclosures of protected materials. These preventative measures ensure that intellectual property remains accessible only to those with legitimate need and that its use is consistent with established policy and legal protections. Respecting third-party rights is equally vital. Organizations must maintain detailed records of all software licenses, subscriptions, and usage rights, ensuring that renewals and terms are actively managed. Policies governing open-source software usage must define how such components are reviewed, approved, and tracked to prevent unintentional license violations. Any content, such as images, training materials, or datasets used from external sources must include proper attribution and proof of authorization. Legal or procurement teams should review all externally sourced materials before integration into products or services. This due diligence not only prevents legal exposure, but also reinforces the organization's reputation for ethical conduct and professionalism in handling intellectual property. Training and awareness programs bring intellectual property protection to life. Employees should understand what constitutes proprietary information, how to identify it, and the consequences of mishandling it. Procurement and project teams must receive targeted reminders about licensing, usage rights, and contract obligations when engaging third parties. Practical case studies illustrating real-world IP violations, fines, or product recalls make the lessons tangible. Ongoing refreshers tied to new products or services ensure that awareness keeps pace with innovation. When employees see IPR as part of everyday professionalism rather than an abstract legal concept, protection becomes a natural outcome of responsible work. Intellectual property considerations are tightly connected to incident response. Many breaches are not about stealing personal data, but about exfiltrating designs, research, or source code. Response playbooks must therefore include specific steps for verifying whether intellectual property was exposed and how far it spread. Legal teams should issue hold notices to preserve relevant evidence, while investigators collaborate with law enforcement or regulators to recover or contain the stolen material. Restoring confidence requires both technical remediation and public assurance that proprietary knowledge remains protected. Linking IPR to the incident management framework ensures that when theft or leakage occurs, the organization can act swiftly and lawfully to mitigate harm and demonstrate control. The global dimension of IPR adds significant complexity. Intellectual property laws differ dramatically between countries, both in what they protect and in how strongly they enforce it. Multinational enterprises must reconcile these differences, ensuring compliance across all jurisdictions where they operate or distribute products. Local counsel often plays a crucial role in interpreting national nuances and aligning global policy with local enforcement realities. Contracts must account for jurisdictional risk by specifying applicable law, dispute mechanisms, and protective clauses. Where intellectual property is shared across borders through research collaborations, outsourcing, or cloud hosting, these agreements must ensure consistent standards of confidentiality, ownership, and recourse. Effective IPR management thus becomes an exercise in global risk harmonization. Audit evidence for A.5.31 and A.5.32 demonstrates that obligations and intellectual property protections are not abstract but operationalized. A compliance register should list all applicable laws, regulations, and contracts with designated owners and review dates. Separate inventories should document software licenses, copyright registrations, and trademark holdings. NDA archives must show which individuals or entities have formal confidentiality obligations and when these were last renewed. Records of training sessions, attendance logs, and awareness materials demonstrate the organization's commitment to educating its workforce. These artifacts collectively prove that legal and intellectual property governance are active components of the IMSS, validated through ongoing review rather than left to legal departments alone. Integration into the continual improvement cycle ensures that legal and IPR governance evolve with the organization. When new laws appear, contracts are renegotiated, or breaches reveal weaknesses, these findings must trigger control updates. Lessons from IPR-related incidents, such as code leaks or research theft, feed back into enhanced policies, access restrictions, or supplier vetting criteria. Contractual terms are refined after disputes or audits to close discovered gaps. Over time, this iterative process builds resilience and maturity, aligning compliance, innovation, and risk management under one unified framework. By institutionalizing this feedback loop, organizations ensure that governance is not reactive but predictive, always one step ahead of change. Together, A.5.31 and A.5.32 create a powerful foundation for organizational integrity. A.5.31 embeds awareness of legal, regulatory, and contractual duties into the ISMS, ensuring that every policy and control has a clear external anchor. A.5.32 protects the intellectual capital that differentiates the organization in a competitive world, while ensuring respect for the creations of others. When these controls operate in harmony, the result is a security program that is both compliant and credible, a system that safeguards innovation, fulfills obligations, and earns the trust of customers, partners, and regulators alike. These principles naturally pave the way for the next controls, A.5.33 and A.5.34, where evidence handling and information management extend this governance discipline into daily operational assurance.